O Instituto tem 1 ano já de existência e a gente tem promovido muitos eventos, dentre eles eventos culturais e acadêmicos. E o evento de hoje é um evento importante, porque a gente está com 2 professores estrangeiros. Um é a professora Ingeborg Schwenzer, que esteve conosco na FAAP, na segunda-feira, tratando dos casos da CISG, né, Comércio Internacional, e também o caso do Premut deste ano. E também temos Joe Liu, de Hong Kong, que ele vai também trazer questões de direito internacional e aspectos chineses. E aqui a gente faz esse diálogo com o público, dos alunos, acadêmicos, jornalistas chineses que estão aqui hoje, para trazer e tirar as dúvidas que se tem entre esses 2 gigantes, que é o Brasil e a China. E aí eu vou passar daqui a pouco já a palavra para os nossos palestrantes. Eu acho que tem muita gente aqui para poder contribuir muito. E dizer que eu estou muito feliz aqui hoje no Rio de Janeiro com nosso amigo Rodrigo, que também lá atrás proporcionou algumas questões interessantes. E eu acho que o Instituto cresceu com a ajuda dos amigos. E eu acho que tem muito mais para crescer. Então, sem mais delongas, eu vou chamar já o presidente da mesa, Dr. Napoleão. I want to thank Professor Ingeborg Schwenzer for coming to Brazil, staying with us in 2 events, one in São Paulo and now one in Rio de Janeiro. And also Joe Liu. He came from Hong Kong, especially to this event in Rio de Janeiro. Thank you, Joe.
Thank you very much, Thomas. Well, first I need to say a big thank you to Ibrachina. Ibrachina and Thomas Law, they kind of took advantage of that. This week we are having an arbitration, a very important arbitration week in Brazil, due to the pre-moots, the 2 main pre-moots of Brazil, the one from São Paulo and the one from Rio. The one from São Paulo organized by CAM-CCBC, and the one from Rio organized by our friends from UERJ, Isabel, Daniel, Bernard, and also Joaquim from Baker McKenzie. And due to the presence of Professor Ingeborg Schwenzer, this week got really more special. And in the end of last year, we started talking, me and Thomas, about how to take advantage of the usage of Hong Kong International Arbitration Center rules into this year's moot problem. And we thought about doing a little bit, not only an arbitration week, but also a China-Brazil week during this period. And that's the idea of the 3 events that we organized this week. The first one there in FAAP, the second one in Fiesp. In Fiesp, we had a problem with one of our the presenters today, Mr. Luis Alberto Salton Peretti. He got a problem in his plane, so he won't be able to join us today. And but the fact is that we divided this presentation today in the first part to talk about Brazil and China relations, especially regarding dispute resolution. Okay, there is a long-standing story of relations between these 2 countries, especially in the last 2 decades, and the history of solving the problems that normally arise from these disputes, these relations, is also a little bit problematic. And we tried to invite the specialists from the main arbitration centers. Mr. Joe Liu is the Secretary General from the Hong Kong International Arbitration Center. Ms. Patrícia Kobayashi is the Secretary General from CAM-CCBC, the main Brazilian arbitration center. We also invited Mr. Peretti, but as I told you, he couldn't attend. And we thought about bringing to this debate 2 very experienced lawyers, practitioners here in Brazil. One, Mr. Joaquim Muniz from Baker McKenzie, and the other, Mr. Rodrigo Moreira. This is the idea today. We are going to first hear Mr. Joe Liu as our special guest, and to see how he sees this relation between China and Brazil and the disputes that come within. And then all the members of the panel are going to try to bring a little bit of their experiences and kind of questions as well. Okay, so I first ask Mr. Joe Liu to join me. Mr. Joe Liu, the Secretary General from Hong Kong International Arbitration Center. Take a seat, please. Now, Ms. Patricia Kobayashi from CCBC. Mr. Joaquim Muniz. And Mr. Rodrigo Moreira.
Thank you very much. Good evening, ladies and gentlemen. First of all, I wanted to thank Ibrachina for inviting me to come to Rio. Despite spending 23 hours on the plane and feeling jet-lagged, I'm still very excited to be here. Now, with such a large amount of Chinese parties participating in HKIC arbitration, I thought it would be useful to share some of my general observations about the key trends and the characteristics about those cases. First is that international arbitration is the preferred dispute resolution mechanism for many Chinese parties in cross-border transactions. And nowadays, Chinese outbound investment tends to focus on emerging and high-risk jurisdictions. So they are attracted to international arbitration because of its worldwide enforceability of arbitral awards under the New York Convention, and a party's ability to choose the arbitrators with the relevant expertise, and the flexible procedures that you can have in international arbitration, such as free choice of language to arbitrate, governing law, and a set of arbitration rules. So these are the reasons why Chinese parties are now, when you are negotiating a dispute resolution mechanism with the Chinese parties, and they will usually propose international arbitration for those type of contracts. And my second observation is the types of disputes that we see from Chinese parties at HKIC. Now, I think the majority of the disputes that we handle involving Chinese parties is corporate disputes, such as disputes arising out of shareholders agreement or share purchase agreement, joint venture agreement, et cetera, et cetera. In addition to that, we also see a large amount of disputes sort of arising in the maritime sector, such as shipping disputes, sale of goods, as well as banking and financial services disputes. Now, many of those disputes involve a variety of governing laws. The most commonly chosen governing law in disputes involving Chinese parties is Hong Kong law. Now, my understanding is that it's not necessarily the first choice of mainland Chinese party, but it's a compromise that both parties, they reach because they were not able to secure the governing law of their respective home jurisdiction. So the usually sort of pattern is that the Chinese party will propose PRC law, and then the other parties may propose the law of their own jurisdiction, and then none of the parties agree to any of the proposals. So they were looking at the law of a third or neutral jurisdiction, and Hong Kong law is usually a mutually acceptable compromise. But there are many disputes that are at our center are governed by PRC law. And I think that is for two reasons. And one is because Chinese parties nowadays are the sort of investors in many of the deals, and they are the ones who bring money to the jurisdiction. So sometimes they have a strong bargaining power, and they are able to secure PRC law in the contract they are negotiating. And I think another reason is there are certain types of contracts under PRC law it is mandatory that you have to choose PRC law to govern the contract, such as a Sino-foreign equitable joint venture contract, or contract for exploitation of natural resources in China. So these types of contract that you have to choose PRC law to govern. You can't choose any other foreign law. Another governing law which we often see in HKIC cases is English law. And that is particularly common in maritime transactions and for historical reasons where English law is typically chosen in charter party or fixture notes. And I think that the next observation is about language. Each year we typically, about 80% of our cases are conducted in English. And the remaining cases are conducted in Chinese or in both Chinese and English. A trend that we have been seeing is that there's increasing number of cases that is being conducted in Chinese. And obviously, in those cases, one side is a Chinese party and the other side sometimes is a non-Chinese speaking party, but for some reason they agree to Chinese as the language of the arbitration. So I thought that was quite an interesting a trend or statistics that I saw in our cases. Now, finally is the seat of arbitration. Like the governing law, the Chinese party tend to focus on sort of follow a typical pattern of negotiation when they're discussing the choice of a seat of arbitration with the other party. They will usually propose a Chinese arbitral institution and a Chinese seat. I think the most common choice is CTAC in Beijing. But depending on the governing law, the bargaining power of the parties, and sometimes foreign parties may not necessarily agree to that. And then the foreign party would propose an institution, a seat of its home jurisdiction, and then the Chinese party might not accept that. And then it's really about a choice of a third jurisdiction, a neutral jurisdiction, which would be more appropriate or suitable for a transaction between the Chinese party and the non-Chinese party. Now, Hong Kong and HKIC often pop up. That is a very popular choice for parties in that kind of scenario to consider. And in our cases, most of the vast majority of the disputes involving Chinese parties are sitting in Hong Kong and handled by us, obviously. But there are other institutions in the seat that the Chinese parties are potentially open to if they are not able to get Hong Kong. And then in some situation, they might be prepared to move on to a further jurisdiction, such as Singapore or other Asian jurisdiction, or even London. So this is the kind of the sort of the trends and the key features that I have observed in our recent cases involving mainland Chinese parties. Now, Chinese parties are only getting more and more sophisticated. And given the global outreach of the Chinese outbound investment, I think it is important and relevant to foreign practitioners and foreign companies to know and be familiar with and some of the practice points when you are dealing with Chinese parties in their disputes. And here I have some points that I wanted to share with you. And I think the first point I wanted to make is about service of documents. It is very critical to make sure that when you are in an arbitration with a Chinese party, make sure that all the documents in the arbitration are properly served on the Chinese party, particularly in situations where the Chinese party is not participating. And in that situation, make sure that you use all possible means of delivery of your documents to Chinese party. Now, there is another interesting thing about sort of a service in relation to Chinese party is that some Chinese companies, although it's less common these days, don't have an official email account. So the representatives of the Chinese companies sometimes use their own personal email address to communicate with the other side in arbitration. And in that situation, it is advisable to make sure that the individuals that are communicating in the arbitration have the authority to represent or to provide some sort of documentary evidence of authority to represent the Chinese party. Otherwise, when you are dealing with issue enforcement, the Chinese company might argue that they were not properly notified of the arbitration proceedings. And the second point is strict compliance with the arbitration agreement. And that is one of the most commonly invoked ground by Chinese courts not to enforce an arbitral award or set aside an arbitral award. So when you are arbitrating with the Chinese party, make sure that all arbitral proceedings are strictly conducted in accordance with the arbitration agreement. And in situations where there are differences between your arbitration agreement and the institutional rules, it is preferable to follow the terms of the arbitration agreement. There have been cases where a Shanghai court refused to enforce a Singapore arbitral award on the basis that the tribunal was not constituted in accordance with the arbitration agreement, which provided for 3 arbitrators. But in that case, the president of the SIC court decided to appoint 1 arbitrator in the case under the expedited procedure. And their argument was that they had the power under the SIC rules to do so, even though the arbitration agreement provided for 3 arbitrators, but the Chinese court didn't accept that. So they felt that if that's what the parties agree in the arbitration agreement, the parties should follow the terms of the arbitration agreement rather than the institutional rules. And if it is necessary to depart from the arbitration agreement, then it is necessary to secure written agreement by all parties. And that would be something that the Chinese court would give effect to in the enforcement context. And my third point is about foreign elements. So if, say, for example, a Brazilian party is entering into a contract or having a dispute with a Chinese party through its onshore entity in mainland China, then it is very important for a Brazilian party to be aware of the foreign elements requirement under PRC law. Under PRC law, if a dispute between 2 Chinese parties that has no foreign element, such dispute cannot be arbitrated outside of mainland China. In that scenario, you can't choose a foreign arbitral institution, including the HKIC. You can't choose a foreign seat of arbitration, including Hong Kong. Everything has to be arbitrated within mainland China. And a foreign-owned enterprise incorporated in China will be considered as a Chinese party rather than a foreign party under PRC law. So it's very important to make sure that you understand the structure of the companies and also make sure that you choose a seat and institution in accordance with PRC law. Otherwise, there will be a risk of a non-enforcement of arbitral awards in mainland China. And there have been a number of cases where the parties, 2 Chinese parties chose a Korean arbitral institutions, and at the end of the day, the Korean arbitral award were not enforced in China. MEDAR, mediation arbitration. I don't know whether that's a familiar topic in this part of the world, but it is a very common practice in China. It has been practiced for many years where Chinese parties are familiar with combining arbitration with mediation. They either start mediation before the arbitration or they suspend the arbitration and go to mediation, depending on the outcome of the mediation and go back to arbitration. A very unusual practice, probably for me as a common law lawyer, unusual, but probably not unusual for them, is that they tend to appoint the same individual as arbitrator and a mediator. Now, that has been proven controversial, particularly in common law jurisdictions such as Hong Kong, where there was once a very high-profile case, arbitral award that was issued in a MEDAR process that was not enforced by the Hong Kong court, although that decision was eventually overturned by the Hong Kong Court of Appeal. But it just highlights the skepticism and also the unfamiliarity with such practice in common law jurisdictions, including Hong Kong. So I think when you're dealing with a Chinese party, be prepared for such hybrid process being proposed by the Chinese party, and be sort of keeping an open mind to explore what that really means. Is that really useful and suitable for your dispute? And if the Chinese party insists on appointing the same individual as arbitrator and a mediator, and perhaps that is something that the foreign party could explore further with the Chinese party, and what is really the merit of having the same individual to decide a dispute or to facilitate dispute resolution in 2 such very distinct processes. And my next point is about discovery and the retention of documents. And not all Chinese parties have a sophisticated system or policy of managing and retaining documents, even for some of the large Chinese companies these days. And their policy and a system of preserving documents is still not requires improvement, and that can lead to a lot of problems in arbitration proceedings, particularly in the process of getting evidence and the document production process. So even though the tribunal ordered the Chinese party to produce certain documents, but the Chinese party, sometimes they will say that actually the document doesn't exist anymore, we lost it, and we thought that it would not be useful, so we just didn't preserve it. So that was some of the practical issues that sometimes might arise in international arbitration involving a Chinese party. My next point is quite an interesting point, and an argument that I sometimes encounter when I was in private practice was that sometimes I saw Chinese parties using referring to a particular mandatory provision of a PRC law to invalidate a contract which provided for a different governing law. So for example, a Chinese party, a Brazilian party, for example, enter into a contract that is governed by English law. But further down the line, when the Brazilian party is pursuing a claim against the Chinese party under the contract, and then the Chinese party said, wait a minute, this contract is void and null under the mandatory provision under PRC law, even though the contract provides for English law to apply. But then if you're going to perform this contract in the PRC, this is invalid because that's what the PRC law says. So that is the kind of argument that sometimes I see when I'm in private practice representing a client against a Chinese party. And a sort of a related point is be mindful of the intervention of Chinese courts, even in arbitration proceedings sitting outside of China. I have seen a few cases where the parties, the Chinese and the non-Chinese party, agree to an arbitration agreement with the seat in Hong Kong, for example. But the mainland Chinese party nonetheless went to the PRC and commenced a Chinese court proceedings, arguing that the arbitration agreement is invalid and seeking some sort of a confirmation, a declaration from the Chinese court. And in some cases, the Chinese court dismissed the action, but in some other cases, the Chinese court actually accepted the jurisdiction. And then they applied Chinese law to determine the arbitration agreement and eventually held that the arbitration agreement was invalid. So, and in that particular case, the Chinese courts even issue an injunction, not against the other party, but against the HKIC and also the tribunal, which is rather unusual because the untenable injunctions usually, or anti-arbitration injunctions usually issued against a party rather than the institution or the tribunal. But in that case, it was issued. But we thought that the Chinese court had no jurisdiction over arbitration in Hong Kong, so we didn't comply with the Chinese court's order. But nonetheless, I think that just highlights a risk sometimes of Chinese courts going beyond China to interfere with foreign arbitration proceedings. And I suppose the next question is, I think for a foreign party's perspective, you need to think about what is really the effect of such a Chinese court order, and what is the remedy that available to a foreign party. For example, should I go to the court of the sea to seek anti-suit injunction against the Chinese party and try to bring it back to Hong Kong arbitration? And whether or not you should actually participate in the Chinese court proceedings to contest jurisdiction of the Chinese courts. So I think these are some of the practical issues that you need to think about. And finally is enforcement. Now, obtaining a favorable award doesn't necessarily mean that that's the end of the battle. And sometimes enforcement proceedings can be lengthy and costly. And particularly in China, when you are trying to enforce a foreign award, including the Hong Kong award, there is a reporting up system, which means that if a local Chinese court is minded not to enforce, it has to report up to the higher people's court. And if the higher people's court is also minded not to enforce, the higher people's court has to report a matter to the Chinese Supreme Court in Beijing. only the Supreme Court has the power not to enforce a foreign award. Now, the intention of that system is obvious. They wanted to ensure high enforceability of foreign awards. But then there are issues with the system. It is an internal procedure, so it's not transparent. Parties are not invited to make submissions during the reporting up system. There's no timeline on the reporting up system. So a local court can sit on the application for a long time and then not referring up to the higher people's court, and there's nothing the higher people's court can do about it. Or in some cases, we have seen some local Chinese court, they simply suspend the arbitration, suspend the enforcement proceedings, given the intervention of a local authority. For example, a local police bureau, say they have commenced a criminal investigations into certain individuals involved in the transactions, or they are looking into this particular transaction to think that there might be corruption involved. So the court, in response to that, the court suspended the enforcement proceedings without a particular deadline or a time limit. So the matter just hung there for a long time, and then the higher courts had enough, they couldn't do anything about it because the matter was not reported up to them. So I think these are just some of the practical issues that we see when the party is trying to enforce the foreign award in mainland China. And as a result of those difficulties, the parties had no other choice but to settle during the enforcement sitting. So even if they won in arbitration, but given the delays and the difficulty and the intervention of various authorities in mainland China, they had to settle for a lower amount. But having said that, I think generally speaking, the enforcement regime in mainland China is improving. And we have a very good working relationship with the Chinese Supreme Court. We have regular dialogue as to how can we improve the enforcement regime in mainland China. So I know that they're taking some steps to address that. But I think another practical point is that if you really having difficulty enforcing an award in mainland China against the Chinese party, think about enforcing that in Hong Kong. And it's a separate and a different legal system. It's governed by the different arbitration law. The courts are different. It's much easier and more straightforward and take less time to enforce the award in Hong Kong. And over 4,000 Chinese companies now have presence in Hong Kong. So that is a strategic way of enforcing against the assets of a Chinese company in Hong Kong. So I think it just think strategically and creatively. If you meet hurdles in China, think about enforcing elsewhere. I think I will stop here.
I will start with a question from me, and then I'll let the others make their questions as well. You talked about a trend that you mentioned about many people arbitrating there in Hong Kong International Arbitration Center in Chinese, even if there is a party that is non-Chinese speaking. Did it happen that during the proceedings they said, well, maybe in the contract I chose Chinese, but I cannot present my case in Chinese, and they asked for you to do it in English? And in that kind of situation, is it common for you to do in both languages? You also mentioned some cases are conducted in both languages. So what's the practical solution that you have when, although a party has chosen the Chinese, in the middle of the proceedings they say, oh, I cannot move on only in Chinese, I need it to be in English? Do you continue with the choice they did in the contract, or in order to preserve the proceedings and make it enforceable under New York Convention, you attend to their request for bilingual proceedings?
So I think there are different situations to that. In most of such cases, the non-Chinese speaking company will engage Chinese counsel to represent them. So in those proceedings, Chinese will still be used, even though the non-Chinese company will say that we propose change the language to English. We will propose both Chinese and English. But until that happens, until that is decided or granted, then the lawyer will still use Chinese to communicate. But there are situations where a non-Chinese speaking company was not represented by Chinese counsel. They just said we just simply don't understand what is going on. And we know that the contract provided for Chinese, but we just can't do anything about it. In that situation, we will use both languages. So we will make sure that we communicate in Chinese, which complies with the arbitration agreement, but also use the language that the other party understands.
Great. Ms. Kobayashi, would you like to begin with some comments and...
Thank you, Thomas Law and Ibrachina for the invitation. It is an honor to be here. I actually saw the panel in São Paulo about the same topic, but this one is probably going to take another road with the presence of Joe Liu here. And when they invited me, they presented me a question that I couldn't answer. It's not going to take too much of your time because I know this is not what you want to hear. But anyways, I would like to share some of the curiosities we see with arbitration between Brazilian and Chinese parties. We actually, I read something about arbitration in China, and I am aware of those problems. And we have now 330 ongoing cases at CAMC-CBC, and we have received 900 cases, a caseload of the institution. And with the foreign investment of China here in Brazil, I found it really curious that in the first search of the proceedings, we had only a handful of proceedings with a Chinese party. I have to note that CAMC-CBC holds almost 50% of the complex cases in Brazil. And it might be a mirror of how foreign investment is going in Brazil. But even though we had such few cases and it was so difficult to tell you something about the proceedings between Brazilians and Chinese that I could actually tell you because of the confidentiality of the proceedings, that wouldn't give away the parties or even the case. Then, with that in mind, I started to study the foreign investment in Brazil by Chinese parties. And I found out that actually most of the cases are between two Brazilian parties that are owned by Chinese institutions. So usually the Brazilian institutions, they don't actually see the Chinese party. You have to go into the documents and to see the controller, the holding, and actually the history of that contract in particular. After doing this little research, I found out that the Chinese parties are actually the first clients, foreign clients of CAMC-CBC, which was pretty new to me. The second one, well, actually, mainland China would be 18%. 2% from Hong Kong. And the second one would be the United States of America. With that in mind, I started searching for peculiarities of this relationship. And I couldn't find any one that could stand out in the sense that, like, cultural differences that Brazilian lawyers should watch out in a proceeding with a Chinese party. The only one I could point out, it was that in 3 of those cases, we had somewhat of a hard time to notify the party in China, mainland China, not the Hong Kong one. It took us 4 to 5 months to notify the party, but they responded the requirement for commencement of the arbitration proceeding, and everything ran kind of smoothly because they had to constitute a lawyer here in Brazil. We had, in at least 2 of the cases, a hard time to determine if the lawyer actually had powers to represent the Chinese party. But this also happens with companies from the Cayman Islands, for example. So we do have a hard time notifying a few companies that are abroad, and sometimes we have a hard time to see if actually the lawyer constituted in the proceeding had the powers to represent. Hearings. Hearings could be somewhat of a challenge in the arbitration proceedings, because you have two languages, because you have a Chinese representative. In a few cases, they don't speak English. So you have a proceeding conducted in English with Brazilian lawyers and being translated sometimes from Portuguese, English, and Chinese, which makes it a little bit more complex, but doable. We had actually Farsi a few weeks ago at Kansas CBC. And you don't have an official Farsi translator. So it was doable, and we didn't see any particular difference. In all of those cases, we had Brazilian lawyers and a Brazilian arbitral tribunal. So the hard part was when the Chinese party was at the hearing, but it wasn't really any different from any foreign party at a proceeding at KMC-CBC. Let me check one information here. I was talking to Peretti in São Paulo, the Secretary General from CSP. We are actually the two main institutions in Brazil, and together we have like 70% of the cases. And I was sharing some of my thoughts on these proceedings, and he actually saw the same thing. It is really hard to see the Chinese party in these proceedings because the name of the company is Brazilian. And we really would like to share more with you what happened. So I started searching at these proceedings, and I saw that in a few cases they had mediation in China before the arbitration proceeding, which is really common. I saw in at least 2 or 3 cases that I could see in the proceedings. And we saw a group of companies working really as a group of companies. So in those cases, you have a third party having a hard time to participate in proceedings. Anyways, these were actually the only issues that I could point out at the KMC-CPC proceedings with Chinese foreign parties. And I have to tell you, Joe Liu, because I was waiting for this moment. You have an arbitral award that was recognized here in Brazil. It is the Hawaii versus Zeno. It was administered by the HKIAC.
Well, I would like to know more information about it, but we can talk about it after.
Well, I have it here, but it's in Portuguese.
Joaquin.
Am I the next one?
Yeah, you're the next one.
Thanks. Thomas Law, you have the right name for the position. Thanks, Ibrachina. Thanks, Joe Liu, Professor Schwenzer, Napoleon for the invitation. It's very, very important to be discussing China and Hong Kong here, because I'll speak as a partner of a big law firm associated with an international firm. And I've been practicing for 20 plus years, and there was a big change in international transactions and international disputes. China is a reality, and a reality that has come to stay here. Like China, depending on how you measure, is the largest country in the world, and will grow much more than United States and the European Union. Somehow is much more stable even than the U.S. Became Brazilian #1 trading partner. It's about to become #1 Brazilian investor. And given the size and the strength of Chinese economy, it is a reality that will continue and will only grow. And you see that in international contracts, and you see that international disputes. You see the trade of China and the economic flow in two areas. First, international trade, especially commodities, and second infrastructure projects. And both of them will result in arbitration, but completely different arbitrations. You see more and more those cases going to either to the Hong Kong International Arbitration Center or to the Singapore International Arbitration Center. And I think there's a huge trend in Brazil to have all those contracts going to either one of those institutions. You see more and more the HKIIC being one of the strongest international centers in the world, instead of going to ICC, Stockholm, or LCIA. And that's very interesting. It's very interesting as a user to see the Hong Kong International Arbitration Center, because you have it's an institution that is in the Chinese system, because it have like one country, two systems. So it's in China, but has a very strong. Hong Kong is a place with a very strong international culture. You have this common law background. So at the end of the day, it's very wise, because you are the best of the two worlds. Like, you are in China, but somehow you are in a common law country. So we are in a place that you know how things are because of the strong common law culture. So see more and more international disputes going to Hong Kong, especially at this first moment in international trade related to commodities. And that makes makes a lot of sense if you think. First, it's in China, but given the culture of Hong Kong, is a neutral place, because it's an international hub. Now I'm going to speak about a tragedy. When there was Brexit, there was a study, and Baker McKenzie participated. What would be the places that would grow, that would benefit from Brexit? And people thought about Paris, Frankfurt, but it's going to be Hong Kong and Singapore, because they are huge economic hubs. They are closer to the clients because money is in Asia. They have a place to grow real estate. They have very educated people, very hardworking people. So I think there's going to be more and more a shift from the Asia. Is not going to be only the big industrial hub. It's going to be a huge service hub, starting with financial service. And like it's a tradition. One of the largest banks in the world is Hong Kong and China, ISBC. So it's for 200 years. Hong Kong has been a big economic hub, but it's going to strengthen. And that there are a lot of educated people. And it's a truly international place. So see those becoming a hub not only for financial service, but also for legal service. And that's one important thing. For some years, the office of Baker McKenzie in Hong Kong were the largest offices in the world, like larger than China, than Chicago, that's at the headquarters. That show how strong in Asia. If we're talking from Latin America, don't have an idea how big they are, and that is somehow it's a change, it's a positive change, because there's a culture of, and if you're dealing with the Hong Kong International Center, you have a very expedited service, like they are very high service, very quick, but we have them to think about how to create this this joint culture, like having more. We're going to have more and more arbitrations in Hong Kong. So there are some concerns. First concerns, the pool of arbitrators, like how gonna have a balanced pool of arbitrations as you have in other centers. That's a very important thing, that you can find people that's neutral, that from all those centers, like ICC, neutrality is one of the key issues. And of course, Hong Kong is neutral per se as a big hub, but how not neutrality as bias, but neutrality as diversity. How have a more diverse center, have people from many jurisdictions, many cultural backgrounds. I think that's curiosity that we have, and I ask you how you're dealing with that. Different legal cultures, how to deal with different legal cultures. So I think that's the first challenge. The first challenge of the trade Brazil and China is it's also it's cultural thing about the relationship itself. But I think that it's quite positive, because what I see is on a business level exactly what you see as a dispute level. Culturally speaking, like Chinese companies normally take over Brazilian companies and keep management. So it's not something top-down. They have a more laissez-faire way of dealing, like allowing the local culture. So that's quite positive. But I see that a lot of disputes are going to happen with all those investments with infrastructure. And then we have a third challenge, that's the language. Because the language is very difficult. It's very difficult for us to have people who speak Mandarin or Cantonese. It's very difficult to have Chinese people knowing Portuguese, or have English as the common language. So I think more and more, I have a couple of cases with Chinese parties, and it's very hard to get like translators. I feel as a Brazilian some kind of insecure that the translation is being properly done. So I think that's something that's going to be addressed over time. But it's a matter of time, because having more and more cases, have more people learning Mandarin and Cantonese, more international relations between those countries. And that's why I'm quite positive that we are starting here to spread the word about international arbitration with China. That's going to be something that in 5 years is going to be a huge reality, and we have to prepare for that. So thank you, Joe, for coming. And then I leave you this question: how are we going to address the issue of cultural diversity? Not only with the main countries, like having Americans, but when you start doing business in Latin America, how are we going to deal with that?
I think from the institution's perspective, I think first is that we need to maintain a diverse team to administer cases involving parties with diverse backgrounds. So for that, it's a work in progress, but we have made, I think, a notable progress. So we currently have a team of 29 members, including members from 14 different countries, and speaking a total of 9 different languages. So, and we have lawyers from civil law and common law backgrounds, and one of our secretary members, Kieran Sangara, as many of you probably know, and she used to be based in Uruguay, and she used to come to Brazil and other South American countries. So this is someone that we have, and she understands the market here, and equally we have somebody who understands other markets with distinct culture and a legal background. So I think from a case management perspective, and we are conscious that it's critical to maintain a diverse team. We have to be diverse. We have to multicultural. And our governing body equally, and we take active steps to make sure that the governing board members are also culturally diverse and multilingual and legally diverse, because they are the people who eventually decide on procedure issues in the HKIC arbitration. And I think another aspect to it is appointment of arbitrators, because eventually the dispute is decided by arbitrators rather than the institution. And normally, in our cases, arbitrators are appointed by parties, but in some cases, arbitrators are appointed by us if there is a default. And then culture background is something that we look into when we decide who to appoint. And we look into the tie, the culture ties, the company, the entity, or the individual has with any particular jurisdiction or multiple jurisdictions. And whether or not it is coming from a civil law background or on a common law background. And we also look at the arbitrators that they nominate and they propose to sort of identify their preferences. So sometimes even though we have a case involving a civil law party, but the civil law party actually appointed a common law arbitrator, and for the case sitting in Hong Kong. So I thought that was quite interesting, and that is something that we will take into account in deciding who we appoint. So I think these are something that the measures or steps that we have taken in actual cases, but outside of the actual cases, it is an ongoing effort for HKIC to go out, to reach out to people, to go to different countries, to understand the local culture, to speak to the lawyers, they understand their tradition, the way how they do business, the way how they resolve disputes, the legal regulatory environment. And that is what I'm doing here in Brazil.
Thank you.
Great. And to end, Mr. Rodrigo Moreira.
Thank you very much, Napoleon. First of all, I would like to reinforce and thank Mr. Thomas Law for the invitation. It's a great pleasure to be here. Actually, I've seen the intense activity of the Ibrachina that is pretty much doing a lot of things, even while dealing with music from Bahia, which is quite impressive, and they are also dealing with events, dealing with international arbitration in China. So, well, pretty interesting. So, congratulations and thank you very much for being here. Joe, it's a pleasure to know you. It's a pleasure to be here with Joaquin, which is a great friend, Napoleon as well. We know each other for almost a decade, which is quite impressive. I'm getting old. But, and Patricia, is also great to see you here. Well, I won't take a lot of your time, and I have a question in the end, but actually I presented some comments on how arbitration in Brazil works. So my presentation is pretty much for you. So the comments I have to make is that, well, as Joaquin said, well, China is the most important trade partner of Brazil nowadays. So in the past 1 or 2 decades, our relationship between our countries became much more intense. And actually, despite of the huge cultural differences, the trade already happens in a very high scale. So, but, however, Brazil has historically no investment arbitration. There are no BITs in Brazil. So it's a traditional position of the Brazilian government. We don't know for how long that we don't sign BITs, and that's just the way it is. It hasn't been a problem to get investment from foreign countries. China is an example. Maybe because, as you said, China has a preference for high-risk venues, so maybe that's why you invest so much in Brazil. But historically, investment disputes are solved by the judiciary in Brazil, which is, well, not perfect, as we all know, but it's quite, let's say, independent and impartial. Of course, we have problems with high-profile cases, but we can say that historically the judiciary power works pretty well. But the new thing is, well, it is very slow, unfortunately. And the good thing is that, at least from 2015, to now, actually in 2015, the law changed. The Brazilian Arbitration Act has changed, and now it clearly authorizes state entities to be part of arbitration agreements and be part of arbitration cases, which is very interesting for investment cases. So although we don't have technically, we don't have investment arbitration, we don't go for ICSID, you can have, for instance, Chinese companies, even directly or through some local company that they may have bought, invest in Brazil, especially infrastructure, which is something that we always expected to have Chinese companies making huge investments in infrastructure in Brazil. They can resort to arbitration, and now the law allows for it. It's been almost 4 years that the law definitely allows for arbitration with state entities, and now it's catching up, let's say, because there is still a cultural resistance from the part of the public administration, from the federal level, from the state level, and in the municipal level. There is a cultural resistance from those public entities to adopt arbitration in those contracts, because they are not actually negotiated, but unilaterally defined by the state entity. So pretty much the public administration has to choose to go to arbitration with the private entity before. But it's catching up. It's becoming more and more common. And what we can say is that the good thing is that Brazil as a venue is actually pretty stable for arbitration, because the judiciary is, we have a solid case law in favor of arbitration. At least so far regarding commercial arbitration, the Superior Court of Justice has been very favorable to arbitration. We can say that the law has been intensively tested in the past 2 decades, so it pretty works quite well. So we don't have so much judicial interference in the arbitration procedures. Of course, there are exceptions, especially in high-profile cases. But in the overall, we can say that the case law is stable, and there is a sympathy from the judiciary regarding arbitration, which is also good for foreign companies that are willing to invest here and having arbitration cases against Brazilian private companies or even state entities, as I told you. Of course, there are some issues to be solved, especially regarding arbitration with state entities. As it's catching up, we don't know how the judiciary will react when the state entities start to lose. So we don't know how they will react. But I believe that there is a tendency for the case law to continue being favorable to arbitration, even in the cases where the state loses some cases. But regarding the Brazilian arbitration market, it's a mature market. The law has almost more than 25 years, but it's constitution for around 20 years. And arbitration has been growing a lot so far. And you have the numbers given by Patricia. They had 900 cases so far. I know Hong Kong International Arbitration Center, you have 500 a year, but you are 1 billion people country, so maybe the proportion is reasonable. But even in any case, we've been having a steady growth of arbitration in the past years. So we can say, it's a mature market, because we have a good legal background. The Brazilian Arbitration Act is based in the UNCITRAL model law. It's not the same, it's a much shorter law, but still inspired in UNCITRAL model law. Brazil is a signatory to the New York Convention. There are some comments to do in this regard, but Brazil is a signatory to the New York Convention, which means that the Brazilian framework regarding arbitration is pretty much aligned with the international standards, which also makes it good for foreign investors, and especially Chinese investors, to do business here and resort to arbitration here, and also as choosing Brazil as a seat, which is an strategic choice, given that if you have an arbitration seated in Brazil, the enforcement is much easier. So if there is a foreign award, let's say there is a Chinese company in a the sale of commodities, you have an arbitration, and well, it's based whatever, anywhere. It can be in China or any other foreign country. In order to make it valid in Brazil, you need to go through an recognition and enforcement procedure before the Superior Court. So the Superior Court acts as a gatekeeper of international awards, international arbitral and judicial awards in Brazil. That, well, it's an obstacle for you. So if a foreign company wants to do business here, it may be a strategic decision to choose Brazil as a seat. And also we have very reliable arbitral institutions. The CCBC it's an international standard arbitral institution in Brazil. We also have FIES, which is also a very reliable institution. We can say that the marketplace for arbitration in Brazil for foreign investors, it's pretty solid, we can say. And lastly, I can say that although, as I said, we don't have BATs in Brazil, the legal framework for the protection of investments is, well, it works pretty much in the same way as the international bilateral investment treaties work. Of course, there are several differences to be made between a BAT and how the Brazilian law works. But the government has no immunity, for instance. So if you have a contract with the government, you can sue the government, and there is no problem. It's in the Constitution that the government can be sued by anyone. Of course, the federal government has a judiciary for itself, which is the federal justice. But still, it has no immunity, and it can be even resort to arbitration against the federal government. And there are protections against expropriation, for instance. So it's not usual. Historically, the Brazilian government doesn't use to expropriate investments, private investments. But if it happens, at least the law says that the investor is entitled to damages in this case. So at least in the basics, although we don't have an international, we don't have a law that specifically addresses international investments, the Brazilian law that applies even to local entities, it can protect investments in the overall. So what I would say to you is that although there are many differences, although Brazil is a developing country, although it's a messy country, I would say, there's still a stable marketplace that can be used by Chinese companies that may be willing to invest in the country. So those were my remarks for you, and I have a question, which is more of a curiosity. Your knowledge of local business people, what are their impression of doing business in Brazil and dealing maybe with arbitration with Brazilian parties or even arbitration in Brazil? It's more of an impression that you may have and more a curiosity of mine. So thank you very much for your attention. And that's it.
Thank you. First of all, I have to thank you for all the useful and insightful information. Within the 5 minutes presentation already, you have a pretty good overview of the arbitration dispute resolution infrastructure in Brazil, both covering commercial and investment treaty disputes. So thank you very much for that. I think in terms of the second question, I think it's a bit of a difficult question for me. I think it's something that I wouldn't be able to respond without doing some proper research. I think in Hong Kong or in mainland China, I think so this is not a topic that has often come up in terms of like their experience in doing business in Brazil. But I think the big picture is that we know that there is a significant amount of Chinese investment in Brazil, and there will continue to be. I think that seems to be the trend. But in terms of the specifics, I think it is something that, with regret, I'm not currently in a position to share any sort of experience or insight I've learned from the people that I have talked to in China or Hong Kong.
Very good. Well, I'd love to continue this panel for the rest of the night, but we still have a second panel. So I open for question, actually only one question from the audience, if you have one.
Via Hong Kong depository receipts, do you have stock market arbitration?
By stock market arbitration, can you
I
elaborate?
mean, you have a dispute between, for instance, a controlling shareholder and minority shareholders, or between the company and the controlling shareholders.
Yeah, we do.
Minorities.
We do.
That's and is it mandatory or is it?
It's not mandatory.
It's not okay.
Yeah.
It's not a listing requirement.
No, it's not.
Thank you.
Well, what I have to say is that China has always been very close to foreigners as a whole, and in the last 20 years they developed a lot. I think it's the biggest, the fastest history of development in the world. It's this last 20 years of China. And now China is facing a period of investing abroad. Every one of you that are involved with the mood, you need to look to this country with special attention. This panel today was intended to give you a taste of China. Think about it. Think about studying a little bit more about the country, studying a little bit more about the language, the culture, and here you had an idea, an overall idea of what will come next. So I'd like to thank all of you, all the panelists today, especially to Mr. Joe Liu that came so far away to this event. And I now invite Mr. Peter Sasser to preside the next panel. Thank you.
To accept it. And I have the distinguished honor to thank Ibrachina and PUC São Paulo, PUC-RJ for sponsoring and organizing this event. Both faculties are certainly among Brazil's 5-star law faculties, and when it comes to private international law and arbitration, at least in my view, you are number one. I now have the great honor to introduce to you the distinguished panelists, although they don't need no introduction because they are part of the Arbitration Champions League. Let me start with Ingeborg Schwenzer, the First Lady of the Swiss Moot Court, a world-famous expert for CISG and private international law. She is of German origin, as I am. And most of you, I want to say this because it's important, I think, that for Brazilians, most of you tend to identify German experts in private international law with the Max Planck Institute in Hamburg. But that is only one pillar of our famous German doctrine in private international law. The second pillar is the distinguished Freiburg School of thought founded by Ernst von Kammerer and Peter Schlechtrim. Particularly when it comes to CISG, the Freiburg School is the most distinguished and influential think tank in Germany, I would say, not Hamburg, because I'm from South Germany. But I studied in Heidelberg, so I'm kind of neutral, almost. Today, no one represents that school of thought better and in a more emblematic way than Ingeborg Schwenzer, who was Schlechtrim's preferred scholar, as I heard from some of my colleagues. Now let me introduce Gilberto Giusti. He is certainly one of Brazil's international star arbitration lawyers. He is not only a partner of Pinheiro Neto, he actually founded the arbitration practice, which is a tier 1 arbitration practice group, highly respected in international arbitration hotspots such as London, Paris, New York, and of course, Hong Kong. Recently, I studied one of Gilberto's articles on the 20 years celebration of the Brazilian arbitration law when preparing my own book on arbitration in Brazil, and I have to say, it was a great pleasure. I'm deeply impressed by his clear, elegant, and at the same time, simple style. His way of writing is just outstanding here in Brazil. Last but not least, he's one of the few Paulistas who seem to really love Rio, which brings us closer together. Unfortunately, I'm not a native Carioca, but my heart and my soul belongs to this city nowadays. That's the most important part. And now let me introduce Daniel Greenbaum. This man is today Brazil's most valuable arbitration counsel, I assume, both in terms of volume and case numbers, because he represents Petrobras. And Petrobras, in many ways, a very special and impressive company from the lawyer's perspective, because I was just amazed. The law department consists of more than 700 lawyers, and therefore it's probably Brazil's largest top-tier full-service law firm. And Daniel coordinates the arbitration practice group of his in-house law firm. Furthermore, he is professor of WERG, and certainly WERG together with PUC is the leading law faculty of this city, at least in the area of commercial and civil law. At this point, I should be carefully and not forget to mention FGV, because I had the honor to give already a lot of classes there. However, FGV nowadays is particularly strong in public law and regulation, not necessarily at the same level in commercial and corporate law. And these topics, public law, built the bridge to Cesar Pereira. He's one of Brazil's leading professors and practitioners in this area. He teaches in PUC São Paulo. His legal opinions are highly wanted and respected in courts and among arbitrators. He runs in São Paulo with his partner his own law firm specializing in public law, as far as I learned this week. And Cesar will certainly allow me also to mention that he has been recently invited to join the list of CAM-CCBC, and notice that also needs no comment. So my limited role is almost done. Let me just kickstart the discussion by asking Ingeborg, what do you think is, from a procedural perspective, the biggest challenge of the actual case of the 16th with moot court?
Thank you, Professor Schwenzer, and thank you, Dr. Zesser, for the kind introduction. Just a small caveat. Although I have two hats, one of counsel for Petrobras and the other one as a law professor, the opinions I might convey here are based on my hat as a professor of law. Justice and I, we decided to, since there are two procedural issues this year, we decided that I should address briefly the first one, the law governing the arbitration agreement, and then he'll go on and tackle the more juicy issue of illegally obtained evidence. So I'll be short. This year's question it's a dream for a private international law professor, because it deals with so many of the classic issues that are traditionally addressed at this discipline. And when the parties have chosen the law, expressed the law applicable to the contract or to the arbitration agreement, it's an easy case. As you know, and at this year there is no express choice of law, at least for the arbitration agreement. Then the arbitral tribunal is faced with a classic question: absent an express choice of law clause, which law governs the issue? Obviously, this year regards the law applicable to the arbitration agreement, but this question has a deeper root, and also could be addressed as which law governs a contract absent the choice of law. There are three different methods, at least classical methods. The first would be for the arbitral tribunal to rely on the private international law rules of the seat of arbitration. That seems to be an old and almost abandoned route. The second method would be for the tribunal to apply the conflict of law rules that it deems appropriate, and that is the model law solution. If you read the model law says that absent an express choice of law, the tribunal should apply the law according to the conflict of law rules that it deems applicable. This is also a bit too complicated, because first the tribunal should find which is the set of conflict of law rules that are applicable, and then find the law that is applicable. And that's why if we look at the Hong Kong chamber rules, it takes a third and different route, which is normally called the voie directe, meaning that the tribunal applies the law that it deems appropriate. Point. You don't have to go through private international law rules. You just apply the rules that you deem applicable. So, which is the law applicable to? How should the tribunal find which is the most appropriate law for the arbitration agreement, absent an express choice? And that's all about this year problem. You might be familiar with the SulAmérica case, which is a very interesting case, and to begin with, because it involved Brazilian parties, not only SulAmérica and ESA, but other parties. The contract was governed, the insurance contract was governed by Brazilian law, but the arbitration had its place in London. One of the parties began proceedings in Brazil against in breach of the arbitration agreement, and then, quite naturally, the other party ran to London English courts and asked for an anti-suit injunction. And at that point, the court has to decide if, first of all, if the arbitration agreement was valid and which law would govern the arbitration agreement. And that's when the three-stage inquiry that I'm sure that most mooties are familiar with has been developed. The court has decided that first one should look at the express choice of the parties, then the implied choice, and absent an implied choice, then the law of the seat. The interesting conclusion of the SulAmérica case is not really coming up with this three-stage inquiry that's intuitive. I think that the interesting part is that when one comes to the second stage, we could assume that implicit choice of law for the arbitration agreement is the same law that the parties have chosen to the main contract. I think that's the interesting part of the case. A leading commentator, an English private international law professor, has said quite rightly that there is an air of irreality in assuming that the parties that have not expressly chosen a law for the arbitration agreement would have impliedly chosen any other law, and that this law would be the same law of the arbitration agreement. I think this is correct, but as a matter of policy, it makes sense. For the purpose of the moot, respondent, claimant might want to argue that this case has been decided by an English court, that the English Arbitration Act has nothing to do with the model law. This is true, but then there are also other cases, in Singapore, for example, the BCI and BCZ case that has also addressed the same point, and since Singapore is a model law country, I think it's a safer case to be cited. I'm just two final points on this year case. If one look at the choice of law clause of the main contract, the choice for the contract, one reads that the sales agreement should be governed by Mediterranean law, the sales agreement. And that's the only time in the whole contract that the parties have used this term, sales agreement. If you look to the contract, I know it's a standard contract, but if you look at the contract, the parties have referred either to contract or agreement. But the only time, the only instance in which the parties have used this term, sales agreement, is when they have, it's in the choice of law clause. So I wonder if this would rebut and would derogate the presumption that when choosing the law applicable to the contract, the parties would also have chosen the law applicable to the arbitration agreement, because precisely of the wording that they have chosen, this sales agreement and not the agreement or the contract. I also find interesting, and I think that, if not mistaken, it's one of the only arbitral rules that chambers that provide that the chambers model clause suggests that the parties expressly indicate that which law would govern the arbitration agreement. I'm not aware of any other chamber that has made such a suggestion. I think it makes a lot of sense, and I wouldn't be surprised if in the future other leading institutions would follow your lead and make such an amendment to their choice of law clause, I might suggest in Petrobras that we do the same, because Petrobras model arbitration clause that I had the honor to draft just provide for the law applicable to the contract and not to the arbitration agreement. But it's after this year's mood, we might consider changing that. Although I might say that the clause provides that not only the agreement, but any questions arising thereof or related thereto, it would also be governed by the same law. So one could argue that this choice of law clause is so broad that it encompasses not only the agreement itself, but also the arbitration agreement. But at this year mood, I think the clause is quite different and narrowly drafted, and the words that the parties have chosen might indicate that they don't want that the same law applies to the arbitration agreement. So with these brief comments, and again, thank you, Thomas Law and Ibrachina, for the kind invitation. It's a great honor to be here. I will pass the mic to my learned colleague.
Yes, well, thank you. Well, first of all, I kindly ask you to allow me to stand up, because besides being a Paulista with a Carioca heart, I also an Italian descendant, so I have to move. I'm sorry. And second, as a follower of Murphy's Law, I woke up this morning with my voice almost failing, so I have to make an effort for you to hear me properly, so allow me to stand up. I also like to thank Thomas for this very, very kind invitation and congratulate you on the super work that has been done by Ibrachina. And before I move, and Mr. Liu, very nice meeting you, Joe. Just something that came up to my mind after I heard the first panel, which was very good, and something that I think Ibrachina may play an important role. Language may be a real problem in future arbitrations. Some time ago, I presided over the tribunal in an arbitration in Portuguese involving a Chinese party and a Brazilian party. And we had a 3-day hearing in which 3 or 4 witnesses from China were heard by video conferencing. And I would say that half of the hearing was lost in the translation, because I remember the witness from China said something, the translator appointed by the tribunal translated in some way, but the party had brought his own translator because he was not confident on the official translator. So we had sometimes 3 different versions. The witness said something, the court-appointed translator would say, he said that the contract should, and the party's translator, no, the contracts must, no, might, no, may. Oh, wow, it took a long time for the proper meaning of what the testimony was saying. Well, thank you very much indeed for the invitation. It's a great pleasure being here, and I promise to be very, very brief, because I know that you all, including myself, want to listen to Professor Schwenzer. So this year's case has 2 interesting procedural issues. The first one was addressed by my colleague Danielle about the applicable law of the contract, law of the arbitration, which is a very exciting issue. And the second issue, at first sight, if you read, it may seem like, well, a minor issue. It's the admission of a piece of evidence in the middle of so many evidence, or so much evidence that are usually produced during the procedures. But no, it's not an irrelevant issue. It's not a minor issue, because you all know, especially in international arbitration, that the production of evidence, the right of a party to produce an evidence, and or the duty or the right of the tribunal to admit it or not, it's maybe crucial in the end of the day, especially in countries of a severe civil code and a codified system like ours. The lack of an evidence that was critical for a party to fully present its case may be a cause of future nullification of the award, because of a breach of the due process of law. On the other hand, the production of an evidence that is later on seen by a court, for instance, as an illicit evidence that was accepted by the tribunal may also lead to a decision that may set the award apart. So it is not a minor issue, the second procedural issue that is in this year's Wismut case. And for those who have not read the case, what is this issue? Claimant, in the course of the arbitration, informed the tribunal, and that sounded weird, to tell you the truth, because informed that claimant will have access to the copy of an award that was issued in another proceeding, arbitration proceeding involving respondent, in which award respondent had admitted that the tariff increase was cause for a contract to be adapted by the other tribunal. And eventually, in this case, respondent defends the opposite. They defend that the tariff level wouldn't be an unforeseen fact that would authorize the adaptation of the contract. So claimant said to the tribunal, we've just been contacted, or we've just been contacted a company of information, an information company. That's a very subtle name of a wiki news company, but anyway. But we've been contacted by an information company, and we are about to acquire a copy of an award that was issued in another arbitration to which respondent is a party by $1,000. And in that award, respondents argue reasons completely contradictory to the reasons they argue in this arbitration. I say it sounds weird because as counsel to the party, I would at least wait for this award to really be available and then just submit it to the tribunal, and then the tribunal will, wow, what do I do with this? But in this case, I don't know why, they announced that they will have a copy of, which that's something that the both parties may explore in the mood, okay? But anyway, on the very following day, respondents came and said, that's absurd. The other arbitration is under confidentiality, and claimant could never have access to that award. And if they submit this award in these proceedings, they will be violating the principle of good faith, because good faith principle in arbitration assumes that no tainted evidence be used by any of the parties. So that's the issue, that's the case, and that's, as I was saying earlier, it is a matter of importance because it may end up in a cause for possible nullification of an award. But what, excuse me for my voice. So what are the elements, basic elements that we have to consider here, both claimant and respondents? First of all, the relevance of this evidence. Is this evidence relevant, really relevant? Well, we don't know yet because the copy wasn't presented to the tribunal, so we are wondering here. Claimant and respondent will have to make some estimate of the contents of the award, because I repeat, the copy has not been submitted yet. It has been announced. But of course, defendant may argue and will argue that it's not relevant because each case is different from the other. And in that case, it was an ICC hardship clause, which is completely different from the peculiar hardship clause that we have in our case, which is a sort of mixture of force majeure, an act of God, together with hardship. If you read the clause in our case, the Wismut case, it was the use of acts of God and force majeure clause complemented with the concept of hardship. It's a sort of Frankenstein. And in the other case, it was a pure ICC hardship. So what's the relevance if you are talking about different contracts. That's what respondents will say. But claimant may debate saying that, well, it's not a question of specific terms, but it's a matter of contradictory behavior, irrespective of the contents of the clause or the wording of the clause. We cannot accept that the respondents say something in one case and another thing in a different case. That would be venire contra factum proprium, because it is also a violation of good faith under the view of the claimant. So the other big issue that is behind it is a very old discussion of what the arbitrator should seek in an arbitration. You know that in criminal law, the judge or the arbitrator, if criminal matters were arbitrable, they should seek what? The true material, the material truth. That's what a criminal law judge is seeking for, because it's criminal nature. In commercial contractual disputes, it's not necessarily the material truth. Why not? Because it is subject to procedures, to formalities, to rules, to agreements. So, if claimant comes with this argument, assuming, no, but we have to seek for the real truth of the facts, irrespective of how the evidence is produced, which would be a version of the end justifies the means, right? I would counter argument as defendant saying, but it's not a criminal panel. I mean, we are not having someone that's going to be sent to prison or not. It's a contractual obligation that has to follow, and the dispute has to follow rules, procedural rules, regulatory rules, and it's not a question of finding the real. And defendant should be careful. Not that I'm saying that I'm wrong. No way. I'm just argumentando, arguing that that's a stupid argument. The material truth. You see, there are many arguments from one side of and the other. But one final point that I would like to address with you, because I'll keep my promise to leave Professor Schwenzer to be the start of the night, because she is the question of confidentiality. We have to have in mind exactly what confidentiality means in arbitration. Does it come from the law? Does it come from the elected rules? Does it come from a contract between the parties? In this specific case, it is said that the award from the other arbitration was stolen or was given to this information company by two former employees of the company who were under a confidentiality agreement with respondents. So they would have violated a contractual obligation of confidentiality with the company by delivering the awards to the information company. I see this differently from a case in which it's not only a contractual breach between a former employee and respondents, but also because it violates the Hong Kong International Arbitration Center, which does have a specific provision that otherwise agreed by the parties, all including the award, all elements, all documents that are objects of this arbitration should be kept confidential, etc., etc. But I'd just like to raise this issue because sometimes when we talk about arbitration, it comes to our mind that confidentiality comes out of the blue. No way. It's not of the nature or of arbitration to be confidential. It is given to the local law, the respective regulations or a contract. So do keep that in mind as well. It's not automatic. That's what I'm saying. Anyway, as I said, this is not a minor issue. The denial by the tribunal of having this evidence produced may represent, in the end of the day, a good argument on the part of claimant that he was not giving the proper opportunity to fully present its case, which is something serious. But admitting this evidence, which, by the way, respondents could say that it would be equivalent to the receipt of stolen goods, right? Admitting this evidence may also end up with a contamination of the award. My suggestion, what would I do as an arbitrator? Whatever the decision I take, it has to be well sustained in the decision. It's my experience that whenever you have this sort of and I wouldn't say dubious situation, but it is in some sort of sense sensitive decision, the tribunal should take a position and should make a full grounding of the decision. That helps a lot the award to be immune from future discussion. Well, that's my brief comments, as I said, because we're all here to listen to Madame Schwenzer and Cesar, of course. I don't know who's next.
I think Cesar will start.
I tried in these a couple of minutes here to pick up a few things in favor of claimant, right? And after you do some of these rounds, you keep seeing the same arguments come up all the time. So I'm reading some of the final memoranda for the Viz East, and I tried to pick up some of the things that they say there that seemed interesting. So just 3 or 4 points here before I turn the mic to Ingeborg. One thing that I found interesting was that, well, we know there are two issues in merits. Well, basically one big issue that it's divided in two relatively artificially. Look at the contract and look at Article 79 CISG for this adaptation of the contract. Now, when we look at the contract, Clause 12, everybody goes to page 14, all that thing. Yes, and another possible, another issue that seems interesting is that when you look, when you interpret that contract, well, as you know, the CISG has a provision specifically dealing with interpretation, which is Article 8. And in the first thing you do, Article 8.1, is to look for the intention of the parties. If you have this Frankenstein clause, as Gilberto put it, it may be hard for you to see the true intention of the parties. So some teams are arguing that you have to move on to the second, not the subjective test, but the objective test of the CISG, Article 8.2, which may allow you to introduce a lot of circumstances that may lead to the conclusion that a reasonable person in the place of the parties or in the place of seller would not have accepted all that risk that buyer is trying to place on seller at this moment. And one very basic figure that some teams generally use is that, as you see during the negotiations, when a seller accepted the DDP arrangement, the price increase was very, very slow. I saw in one of the, it's $20,000 in comparison with $10 million total contract, total contract price. I saw in one of the memoranda there was even like a graph, showing the big difference, this big rectangle and this really small one here, the additional price. So these circumstances may lead to an objective idea that no reasonable person would have incurred that type of risk. Another discussion that seems interesting is when you discuss, when you try to imagine what is comparable to those health and insurance issues. What exactly is the operative notion for that comparison? And it's very easy to understand that tariffs are a foreseeable aspect of the DDP arrangement, right? Since duty is paid under that arrangement, tariffs are there and they're foreseeable. But on the other hand, there is a whole discussion based on the idea of tariffs as barriers, tariffs as regulatory measures that assimilate tariffs to the same type of government government measures that induce behavior, such as health or safety regulations. And finally, to go into the second aspect of this issue, the idea of how to apply the CISG Article 79, if we understand that Clause 12 is not a derogation from Article 79, if under Article 6. So if we actually get to apply the CISG, an interesting discussion is, and I know Ingeborg will go there, is what kind of remedy there would be from the acknowledgement of hardship by the CISG under Article 79. And in one concept that seems very interesting in that regard is the idea of performance despite hardship. Hardship usually leads to either a renegotiation or to an exemption of liability. In the discussion here would be what happens if you, in spite of hardship, you perform. I thought one angle that a team used in that regard that seemed interesting was the interplay between that and the duty to mitigate. And what they said was that since by performing, a seller in this case actually reduced the other party's damages, the other party's harm that would be caused by not performing. It was actually a combination of the duty to mitigate with this idea of making this extra effort to perform despite hardship. Well, but anyway, these are just some comments, and I said this was just going to be my opening act to Ingeborg, who is really who we all want to hear. Thank you.
Thank you so much, Cesar. I think you really solved the case already. At least you mentioned all the relevant points that the students have to discuss. And I think what this case, this problem, really emphasizes, and what is very important, and that is the relationship between the contract and the otherwise applicable law. So for each party, for each side, be it claimant or respondent, it's primarily Clause 12 that you have to discuss. And if you want to come to the CISG or then maybe the UNIDROIT principles, it's only if you have doubts about the interpretation of the clause. So you start with a clause, and if you come to the conclusion that the clause is clear in the respondent's sense, that means that the clause doesn't cover hardship in form of the imposition of tariffs, for example, or that the clause doesn't allow for an adaptation of the contract, then that's the end of the game. If you can convince the tribunal about this, that would be fantastic. Then the respondent has won, because then the contract derogated Article 79, it varied, which is always possible under Article 6 of the CISG. So you start from the clause, and then there are three questions, I think, for both sides. The first one is hardship in form of the imposition of tariffs covered by Clause 12? The second question then is the imposition of a tariff of 30%, is that a case of hardship? And then the third question is, what are the consequences? Is adaptation of the contract a possible consequence of hardship? So that's about what the whole case is about. And there, indeed, you can argue with the Caesar in favor of claimant, and you can also, I think, well, actually, Caesar mentioned it at the beginning, and I will now be a bit more theoretical, because I will discuss the remedies for hardship in general, which would lead me, my theoretical position would lead me to the conclusion I do not favor an adaptation of contract. So let me be a bit more theoretical, also to give you the theoretical background. Hardship now is recognized almost worldwide, actually, in domestic legal systems, especially of civil law descent, where we had France being the only or one of the few civil law countries that never recognized hardship. In 2016, the French Civil Code was amended, and they, as regarded hardship, they followed more or less the UNIDROIT principles, actually. It's recognized by the international instruments, you all know, by the UNIDROIT principles, and it's also, I would say, the prevailing opinion is also to recognize it under Article 79 CISG. But the consequences are under huge discussion, and especially the consequences provided for in the UNIDROIT principles, namely duty to renegotiate, adaptation of the contract, or as a last resort, termination by court or by tribunal. Let me first turn to the duty to renegotiate, which is not part of this year's Wismut problem, but that is also very much under discussion. Well, first of all, it's up to the parties to provide in their contract if they want a duty to renegotiate. And if you look into practice, especially of long-term supply contract, they all contain such a duty to renegotiate if you had a fluctuation in the market. Also, the ICC 2003 hardship clause contains such a duty to renegotiate, as well as the UNIDROIT principles. This is not true. You don't find a duty to renegotiate in the American Uniform Commercial Code, that also has recognizes some kind of hardship. You don't find it in the German Bürgerliches Gesetzbuch, in the Italian Codice Civile, in the Dutch Bürgerlijk Wetboek. They all don't have such a duty to renegotiate. In the CISG, there's a lot of writing by legal scholars, and especially I find it very interesting, especially Asian scholars. Chinese and Japanese scholars, they love this duty to renegotiate. So actually it prompted in April, long before the mood problem was published, I got several Sino-Australian scholar sent me the draft of his PhD thesis. A Japanese scholar sent me an article. They were all dealing with hardship and these wonderful consequences under the UNIDROIT principles and how to import them into the CISG via Article 7. And so that prompted in me the need to first to give a paper at a conference in October already, and now to publish a paper together with a Mexican colleague, duty to renegotiate and adaptation of the contract in cases of hardship. This article will be published. It's not yet published, but it will be published in the Uniform Law Review in the next issue, actually. So that was long before the mood problem came out. Well, let me tell you why I don't think that we should embrace the remedy of duty to renegotiation. First of all, I think it's a question of party autonomy. Yeah, it's up to the parties to provide for such a duty. And in my view, negotiation as well as renegotiation is based on trust. And if the parties do not trust one another anymore, there's no room for renegotiation. And there's only one set of rules, and those are the principles of European contract law that contain a sanction if the duty to renegotiate is breached. All the other sets of rules, neither the UNIDROIT principles nor the ICC hardship clause, provide for such a sanction. And if you have a duty without a sanction, so what? And in the end, I think there are many procedural approaches that are better suited than a substantive duty to renegotiate. For example, under many domestic procedural laws, you have the duty, or you have mediation preceding litigation. And mediation aims at an agreement of the parties. In arbitration, you have multi-tier dispute resolution clauses that call for negotiation, mediation, and then only arbitration. So I think these procedural rules are better suited to impose a duty to negotiate between the parties than any substantive law. Let me come to the adaptation of the contract by court or tribunal. I think, again, it's a question of party autonomy. And again, many long-term contracts provide for an adaptation by a third party. Yeah, that there is an expert who adapts the price according to the development of the market, for example. Adaptation you find in the UNIDROIT principles. You find it in many civil law countries, like in Germany, now also in France, in Switzerland. But there's no adaptation under the ICC Hardship Clause 2003, actually. They don't have this remedy anymore, because the ICC Hardship Clause of 1985 had a provision for adaptation of the contract, and it was deleted in the Hardship Clause 2003 because it was never used, actually. So under the CISG, again, it is discussed whether we can rely on Article 7.2 because there's a gap in Article 79 as regards the consequences for hardship. So this Japanese scholar who sent me his article, he argues that adaptation is a general principle under the CISG, because we have Article 50, the provision on a reduction of the purchase price in case of non-conformity of the goods. And he says this is a general principle under the CISG. Well, I do not quite agree with this position. And then again, 7 para 2 of the CISG and going to the UNIDROIT principles as general principles of the CISG. Well, I think that is very, very doubtful, but there is a question of interpretation of the convention. And well, there are different views on this question. Again, I think adaptation of the contract is neither necessary nor desirable in cases of hardship. And why? I think we have to distinguish two scenarios. The one is the long-term contract, where the contract has not been fulfilled and where adaptation would work for the future. And the other scenario is the one we have here in the mood problem, where the contract has been fulfilled by one side, by the party who has been aggrieved by the hardship situation. So let me first turn to the first scenario. Why do I think adaptation is not desirable? First of all, I think adaptation in most cases comes too late. If you think about the length of proceedings, not only court proceeding but also arbitral proceedings, if you have an award, then if the parties are really fighting, then you'll have set-aside proceedings. If the set-aside proceedings are over, you'll have enforcement proceedings. Depending on the country where you want to enforce the award, they might go through 3 instances, the enforcement proceedings. So all in all, you might have 8, 9, even more years until you know about the adaptation of the contract, yeah? So the contract is in kind of a limbo, yeah, for 10 years. So adaptation comes too late for the parties. I think it's also against party autonomy, yeah, because if the parties do not provide for an adaptation, we cannot force it upon them. And I think it does not solve the parties' problems. Because if the parties up to arbitration litigation did not come to an agreement, they really have big problems with one another. And they will not stop fighting if a tribunal or court adapts the contract. There's a very good English case about specific performance. It was still the House of Lords at that time, and Lord Hoffman, who gave the majority opinion of the court. And that was a long-term contract, a lease contract in a shopping mall, where one store stopped because they didn't want to go on, and the owner of the shopping mall tried to get a specific performance decree that the shop owner should continue selling in its shop. And Lord Hoffman said it does not make sense to have a decree of specific performance in such a case if the parties are fighting each other like this, they will come to court all the time. We will not solve their problems by decreeing specific performance. And I think the same is true if we adapt a contract in a case where the parties are entirely disagree with one another. So how about if the contract is fulfilled? Well, what has to be said, even the UNIDROIT principles do not want to adapt the contract in such a case. If you go to the official comment of the hardship provision, there is an indication that there will be no adaptation of the contract if the contract has been fulfilled. And if you go to the commentary by Stefan Vogenauer, McKendrick is authoring the provision on hardship. He also says clearly in cases where the contract is fulfilled, there is no adaptation retroactively. So I think, and we have, in such a case, we as a tribunal or a court has to decide, well, was the contract amended maybe? Did the buyer accept an increase in the purchase price by accepting the goods? Because it knew perfectly well that the seller wanted to adapt the purchase price to the changed circumstances. So the buyer accepted the goods. Or did the seller act at its own risk? So let me just, so you see my skepticism about the duty to renegotiate and also the remedy of adaptation of the contract. The last remedy provided for by the UNIDROIT principle, termination by the court or the tribunal, well, this is just systematic nonsense. Because all remedies under the CISG and following under the UNIDROIT principles are exercised by declaration, yeah? Even reduction of the purchase price, avoidance, or in the terminology of the UNIDROIT principles, termination is exercised by declaration by one party. We don't have that system. That's a French system, actually. Termination of a contract by the court and not by the parties. So that is, in my view, that just doesn't make sense, and it doesn't fit into the modern system of remedies in general. So I think the remedies under the CISG, they are perfect, and they suit the situation of hardship perfectly, and that is indeed the party aggrieved by the hardship situation is exempted from liability under Article 79. The other party may avoid the contract if the non-delivery of the goods amounts to a fundamental breach of contract. So I think we do not need all that exercise and all that exercise with boa fide. I know you Brazilians love it. So we don't need that. We just have to clearly apply the remedies under the CISG and interpret the parties' behavior, and then we can come to acceptable results. Thank you very much.
So thank you very much. And I would like to pick up that you mentioned boa fide. And I think this case, the merits of the case, are particularly tricky for Brazilian students. Why? I was trained as a German lawyer. Then I practiced 12 years with an English law firm, basically applying English contract law to project finance, asset finance. And then I moved to Brazil, studied Brazilian law, and made the local bar exam. And there's one thing that is very tricky when you are working in different legal systems. You are biased. And basically you are biased by the first legal system you learned. So you are biased by Brazilian law. You are biased by Article 422, 317, and 478. So the tendency of Brazilian lawyers, courts, to interfere into the wording is quite strong, let's say. Germany is somewhere in the middle. An English judge, a Hong Kong judge, would almost never interfere into the wording of a contract. That is why we discussed this week in Sao Paulo. There's a very famous clause that our friend from Petrobras will know very well, the take or pay clause or the throughput clause, that is very problematic under Brazilian law. An English judge would never ever think to have some doubts about that clause. In Germany, probably not. In Brazil, dangerous. So be carefully with the fact that you are biased, because you have to resolve this case not on the basis of Brazilian law, Brazilian dogmatic, but eventually, as Professor Schwenzer said, basically interpretation of the contract, and eventually CSIG, which has a completely different mind setting. And you will also have arbitrators, in Vienna especially, that will be biased by a different legal system, not by the Brazilian one. And you have to take this strategically into consideration. So I think it's probably also late. I do not exactly know what is my function now, but I think I should hand over the microphone to you, because you are responsible for this event.
Okay, so I want to say thank you for all the speakers. Dizer que mais uma vez é uma grande honra estar com todo mundo aqui, os grandes especialistas na área de arbitragem, e agradecer a todos pelo evento, mais um sucesso de evento, e dizer que está encerrado os trabalhos de hoje. Muito obrigado. Thank you.